Morning, everyone. Can everyone see that PowerPoint? How's it going? So here this morning, we have some special guests, but this is the third work group meeting. I'm going to just turn it over to Henderson, and he can go over our agenda.
Good morning. Glad to be with everybody. We've got an ambitious agenda. We've tweaked it a little bit since what was distributed, just to sort of hopefully make the flow a little bit easier and smoother as we go through the rather packed agenda. Today, for the first time, we'll have two guests with us. Ben Finholt from the Prisoners Legal Services and Emily Coward from the School of Government. As a first matter, the meetings from last week's meeting, working group meeting, was distributed last week, and we'll put the minutes before the body. Are there any comments, questions, concerns related to the minutes?
Henderson, no concerns. Josh Stein joining a minute late. Pleasure to be with everybody. Good
morning, Josh. And I think I saw Justice Earls join us a moment ago as well. Okay. Good morning, Justice Earls. So hearing no concerns or questions about the minutes, I'll entertain a motion.
Motion to approve the minutes.
Second?
Second.
Okay, well, we'll accept the minutes, adopt the minutes as approved. As indicated, we've got a very full agenda. We're going to combine and curtail some of the items on the agenda. So we'll go from this item 1 immediately to a review of comments from the listening sessions that were conducted the week before. Then we'll entertain 2 presentations, one from Emily Coward at the School of Government, the other from Ben Finholt. We'll look to Karen and Michael to help facilitate some of the conversation around both of those issues. We're going to ask Mary to articulate what we've sort of distributed among the working group, and that is bubbled up from our discussions about conditions at the prisons and the recommendation regarding expansion of the clemency powers. And following that, we've got a discussion of what we've charted out as a fairly robust and ambitious work schedule for this group, some of which we hope to have real productive conversation this morning, but that conversation may in fact get extended. And so to the extent we can't contain all of that conversation in this morning's meeting, we should feel free to entertain continued and extensive offline conversations about how the future meetings are scheduled and the content of those meetings. But first, we're going to ask Malia, who listened and looked through the listening sessions, to bring some of the highlights of those listening sessions. Malia?
Yeah. Sorry, Mercedes, you can go.
Yeah, I was going to say, we had very quickly for Karen and or Michael to go very quickly over what we wanted the meeting to have the outcome very quickly.
Right. Yeah. So you have the agenda in front of you, but in terms of the outcomes, we're really looking for, as Henderson said a little bit later on in the agenda, looking at a proposed schedule, schedule around the work group and what we're hoping to accomplish there. And then, of course, as you heard, we have speakers that'll be talking to us today about jury selections and extreme sentencing. So that is an outcome as well. And then definitely an outcome around any recommendations that we might have for the upcoming task force meeting. So that's it.
Good morning, everyone. I just wanted to talk really quickly about the listening sessions that we've been having. They have been really great opportunities to hear from the community on a number of things. It encompasses the entire task force, so a lot of it was also about policing. So I just wanted to highlight some of the themes that applied most to our working group, in case it's helpful in any proposals moving forward, or maybe the prioritization of some items over others. So there was the overcriminalization of low-level offenses. A lot of this conversation focused on decriminalizing marijuana. There was also discussion on the death penalty. They talked about diversities within courtrooms. So that's mentioning bailiffs, attorneys, magistrates, just staff in general in courtrooms. Greatest access for minorities to be on juries. That had a lot to do with what we've already been talking about, trying to see if jurors can get paid more, things of that realm. Bail bonds reform, fines and fees, of course. There's one suggestion of eliminating district attorneys' control over superior court calendars. And then there's prosecuting and reviewing cases in a timely manner. This comment specifically also related to COVID-19 concerns. And then finally, there was quite a bit of discussion on restorative justice, which I think fits in really well with this group. The link under public input resource isn't something that we want to stress working groups to spend a lot of time on, but if you ever want to take a look in there, myself and another intern are going to be going through essentially, which is like a cumulative dump of every public opinion, whether it's put in through an actual letter, an email, or any of the other sources that they have. Myself and another intern are going to go through and kind of parse out which we think are good for different working groups and which are most relevant to move forward with and which are more just general comments. The last thing that I wanted to touch on is agenda and minute deadlines. We decided that on Fridays we would likely upload both the agenda and minutes. So in case that's ever helpful, if anybody wants to give any input or with any work that goes on outside of the meetings, because I know we're going to start having 2-week spaces in between meetings, it may be helpful just to keep that in mind.
Thank you, Malia. I think that the conversations that have been conducted in the listening sessions have been extraordinary, and we appreciate your effort to summarize and bring those to our attention. Let me just note that last week we also had a very important decision by the North Carolina Supreme Court in State versus Marcus Robinson. And Mercedes, I think it would be helpful just to make, and Malia, just make that opinion part of the minutes. I think the discussion by the Supreme Court about our state's history with respect to discrimination, racial discrimination, the jury selection system is incredibly informative and insightful on the issues that are before the committee. Well, thank you for that look back to the week that was, and we're prepared to go forward with this morning's agenda. With very little to do, I'm going to introduce our first guest presenter, and Emily joined us just a few minutes ago. We weren't able to introduce her, but good morning, Emily.
Good morning. Thank you for having me.
And thank you for agreeing to help us think through some of the difficult and important issues related to jury selection and their impact on racial equity in the criminal justice system. So Emily, please.
Let me just see if I can pull up my PowerPoint here and then I'll get started. Can you all see my PowerPoint?
And
Okay. Thank you so much for inviting me to speak to you today. I want to thank you for the work you're doing. It's critical work at a critical time, and I'm really pleased to know that you're paying such close attention to issues around juries, racial equity in juries, jury discrimination in North Carolina, that whole assortment of issues. These are issues I've been looking at very carefully for the last several years at the School of Government, and I'm really pleased to have an opportunity to discuss them with you today. My name is Emily Coward. I am the project attorney for the North Carolina Racial Equity Project at the School of Government. That's a project that trains primarily defense attorneys around the state on addressing issues of racial equity in the criminal process. I want to note that we're also on the cusp of launching a larger racial equity education project at the school, which will focus on all court actors as well as law enforcement. So that's a very exciting project for us. The North Carolina Racial Equity Network will be under that larger umbrella. And so we look forward to responding to the needs identified by the task force as we move forward with that work. Let's see here. So just to give you a little bit of information about what I intend to cover today, I just want to share with you, so that we're all using the same language, how I think about racial equity, particularly in the context of jury selection and juries more broadly. I want to talk a bit about the historical legacy of race-based juror exclusion in North Carolina and in our nation more broadly. I want to talk about why it matters. I know that you on the work group and those of you tuning in are probably well aware of why it matters, but it would be a mistake not to mention how critically important these issues are as we look at possible reforms. And then I want to think about possible reforms with you. And I've seen the list of those you're already considering. It's a great and very comprehensive list. And I see the reforms that you all have already started discussing and that I've seen adopted around the country falling into sort of 4 categories. Reforms aimed at ensuring that jury pools reflect the surrounding communities. So these are fair cross-section issues around who are on the juror list. Are they inclusive? This would also encompass the issue of juror pay that Henderson mentioned recently, the whole kind of array of issues related to making sure that all citizens are welcome and able, and that jury service is not restricted to any class of citizens, but is broadly available to all, and that all are welcome to serve. The Batson standard, I know there's been discussion of Batson issues. Obviously, there was a Racial Justice Act opinion from our North Carolina Supreme Court last Friday. This is a big issue right now, and around the country, people are looking at ways to strengthen the Batson standard, and I think that's something this task force should be looking at as well. I know you already are. The issue of juror bias, how to keep overtly biased people off of juries, and also how to address implicit bias with people who are showing up to serve as jurors and eventually make it onto juries. The whole range of issues around making sure that juror decisions and convictions in particular are not infected with juror bias. And then data to monitor progress in all these areas. How do we know if we have an inclusive, representative, non-discriminatory jury system? I think there are a lot of improvements that could be made in the type of data that we collect and transparency related to juror data. So I'm going to speak about all of these areas, and I'm going to start just by recognizing that I know this task force has been convened for the purpose of promoting racial equity and eliminating racially disparate outcomes in the criminal process. And so I think that it's important, and maybe you all have already had conversations about language, just to think about what we mean when we say racial equity. And one working definition that I would offer that I use in my work is that we will know we've achieved racial equity when we can no longer predict outcomes on the basis of race. And so when we are looking at an issue like juries with an equity lens, we are using a lens that's historically informed, focuses on systems rather than individuals, and on outcomes rather than intent, which is right away, you'll see a sort of tension with the Batson standard and the ways that we commonly look at jury discrimination. And so I just want to touch briefly on the history here, which I know you're all well aware of. We have a longstanding issue with discrimination and exclusion of Black people and people of color from juries. This is well documented in North Carolina and around the nation. I have put together a Google Drive with supporting materials where you can find all of the studies and reports that I'll mention today, but one that I think is incredibly important is the EJI report on this subject, where they note that the underrepresentation and exclusion of people of color from juries has seriously undermined the credibility and reliability of the criminal justice system, and there's an urgent need to eliminate this practice. We have seen in the last 15 or 20 years a number of studies in North Carolina that unfortunately reflect the fact that this is not just a historical phenomenon, jury discrimination. We've seen studies from MSU researchers, from Wake Forest University, from the Jury Sunshine Project, reflecting that Black potential jurors in North Carolina are removed from juries at twice and sometimes 3 times the rate of their white counterparts. This is in spite of the fact that it's been the case since 1880, if not before, that our US Supreme Court and our North Carolina Supreme Court have held that the Equal Protection Clause prevents the race-based exclusion of jurors from jury service. In practice, that has been very hard to enforce. Both the legal protections and the legal standard has been shifting over time, and also the type of discrimination, from restricting who's on the list, from poll taxes, literacy taxes, to more removals based on peremptory challenges. That's shifted over time, but one thing that has not shifted is the underrepresentation and exclusion of people of color from North Carolina juries. And this is not just a North Carolina phenomenon, it's across the country. And just Friday, as Henderson mentioned, our North Carolina Supreme Court recognized in State versus Marcus Robinson, an RJA case, that the ability to serve on a jury is one of the many ways African Americans have struggled to participate in our democratic processes. I think this is a really important point to think about, because we know, people often complain about being called for jury service, and it's not oftentimes maybe the loudest concern of civil rights groups or of people organizing around racial justice. However, since our founding, it's really been seen as a critical element of citizenship, equal in stature and importance to the right to vote. And this was recognized by our founders, by abolitionists, by civil rights activists and litigators, attorneys through the civil rights movement. And so this has been just a site of struggle around targeted efforts to suppress Black political participation, and also efforts to gain full citizenship for Black people and people of color in our country.
Emily, let me interrupt you here because, as you mentioned earlier in your PowerPoint, the working group has bitten down on a couple of these issues. And I know that Judge Thornburg had made comment at one of our earlier meetings regarding both a video that was produced out of the state of Washington, the federal court there, and his efforts, and perhaps the efforts of other individual judges, to craft language probing or instructing jurors about implicit bias. Can you say a word about what the School of Government is doing in either of those areas?
Sure, I'd be happy to. That's towards the end of what I was going to discuss. I can skip ahead to that. We are, like I said, there are 4 different ways that I think this working group should be thinking about these issues, and one of them is certainly efforts to address juror implicit bias. I know you're well aware of the Washington video. I know Judge Thornburg has been on the cutting edge of innovating in this area in North Carolina. I have convened a video advisory group of North Carolina stakeholders who are currently working to develop a North Carolina version of that video. And we have been meeting now for a couple months. We have about 12 members, I believe, from around the state, district attorneys. Well, we have Spencer Merriweather, we have 2 judges, a retired judge, a trial court administrator, a clerk of court. It's a broad group from broad geographically, racially, in terms of court role. And so we are well underway in working on developing a North Carolina version of that video. We are also looking to propose pattern jury instructions on implicit bias and gathering examples. So I do want to make the task force aware of that project and to get your input as we move forward with it. We are not at a point where we can really share any draft because we've only been meeting for about a month and a half and are still kind of collecting materials and gathering our plans. But it's very exciting, and it's great to know that this group is interested in that. Henderson, would you like me to back up and speak about some of these other types of reforms, or would you like to speak more about the juror implicit bias issue first?
No, I think it would be helpful if you were to comment on 2 specific reforms.
Okay.
One is the increase in juror pay, and the other is the expansion of the list from which jurors, potential jurors, are selected.
Great. Sure. So I think that you've identified 2 very important potential reforms. As you know, jurors are paid $12 for the first day and $20 thereafter in North Carolina. This is on the low end nationally. I am aware of research that you all might have also seen showing that you have a 25% increase in juror yield when you have a higher pay for jurors. And what we've also seen from the research on juror representativeness is whenever you increase juror yield, you also increase juror diversity and representativeness. I believe that in Washington state, where they've looked at this issue, they found that economic hardship was either the first or second most common reason that people were excused from jury service. So we know that we're missing a huge swath of our community, more likely to be people of color, working class people, from jury service, and not getting the full voice of the community in the jury box when we limit juror pay to such a very, very small amount. So I've put some supporting materials around that issue in the Google Drive that I've prepared for you all. As to source lists, I do think that our source lists are missing a huge portion of our community. There have been reforms in other states, including New York State, to include lists such as, so right now we have jurors and voters, and at the county level, jury commissions may supplement those lists with other lists that they deem to be reliable, but in practice, I don't believe that's happening in any North Carolina county. In other states, they have found that adding lists, including tax lists, lists of people applying for public assistance, lists of newly naturalized citizens, and many other types of lists have been very successful in diversifying the jury pool. We also are behind other states in how frequently we update jury lists. We do it every 2 years in North Carolina, unless requested by, I believe, the senior resident Superior Court judge to do it annually, which I think is only happening in 2 counties. In New York, for example, they update the list every 6 weeks, which they have found captures a lot more people who may be more likely to move frequently. There's a real issue with undeliverables in many counties in North Carolina, and I have to believe that the infrequency of how of our updating of our list has a lot to do with that, and that we're missing big portions of the population because of that problem. The slide that I have on ensuring that jury pools reflect communities lists some other reforms that have shown, have demonstrated potential to increase juror diversity and representation. So sending additional mailings, just running addresses through the USPS database, ending the authority of jury commissioners to remove names from master jury lists. This is possible under the statute right now. And while I don't know of it happening, it seems as though it would lend itself to potential, arbitrariness and it's certainly unreviewable. And then transparency to juror data. It's very hard to get these lists. And another reform that is being considered alongside jury pay increases in Washington is there's at least one courthouse in Kent, Washington, where they offer childcare, which has, I believe, demonstrated that can have a huge effect on the ability of people who otherwise would not be able to serve on a jury being able to serve.
Emily, let me interrupt again. I'm going to ask Mercedes for a lifeline question here, and that is how we're doing with respect to the agenda and time. Well, my inner clock is telling me that we are getting pressed.
If we can give her about 3 more minutes, that would be, I think, maybe address some of the other recommendations.
Very good. Emily?
Yes, I'd be happy to. And just to let you know, I mean, each one of these slides is typically something that I maybe teach on for an hour. So
yes,
feel free to come back to me with questions. I'm happy to work with this group in whatever way would be useful to you. You're obviously aware of the Batson reforms in Washington state, where there's been recognition that the focus on an intentional bad actor and proving intentional discrimination has been largely a failure, and that there has not been much Batson enforcement in Washington, as there has not been in North Carolina. So there are also issues in North Carolina regarding not having the data with which to review Batson challenges on appeal. So consistently recording jury selection, consistently having jurors self-identify race and gender would be huge developments in terms of just guaranteeing the right to non-discriminatory jury selection. Also mandatory racial equity and implicit bias training for attorneys regarding jury selection. I have worked with other attorneys to develop an implicit bias desk card that can be used in jury selection to ensure that jury selection is not influenced by implicit bias. And I think education is a huge piece of this as well. I know Judge Thornburg and others on this working group are well aware of efforts to address juror bias. And I would just add that I think another area that is critical is making sure that attorneys are able to explore issues of race with jurors and bias with jurors during jury selection to ensure that they are able to remove people with evident racial bias and to really signal to the jurors that they need to be considering these issues very seriously. And I would also just want to stress that I think that if we are collecting jury data on who is showing up for jury service, who is struck, who is challenged for cause, we will have so much more information about how we end up with the juries that we end up with. And we should have that information both for the public and for attorneys. When people are excluded from juries, the harm caused by it not only affects the defendant, but also the person excluded. And it really sends a signal of second-class citizenship to communities of color. And so I think that looking very carefully at reforms in all of these areas is critically important for this group. And I look forward to deeper engagement with you all on these issues.
Thank you, Emily. I think we'll entertain just a minute or two of questions from members. So I'll open it up to the floor to any folks that have questions for Emily on the sort of broad issue that we've asked her to talk about, jury selection and its impact on racial equity in the system.
we are right on time. So anybody that has any questions, please don't be shy.
Yeah, Emily very generously has offered herself to this working group and to the task force. So this is a continuing conversation that we're having. It's important to note that some of the suggestions that Emily has talked about and that we have put on the table are questions that have been long investigated and reviewed by academics and practitioners and the courts. I can remember 30 years ago, the first time that we looked at the source lists and the impact of the source list on who appears for jury service. And, you know, Mike, questions vary from each county as to how the jury commissioner in a particular county puts together the source list for jury selection. There's a lot of studies in terms of how we can make jurors more representative by adjusting and expanding source lists. One thing that we need to think about is this is an area where we're likely to have some recommendations that we can lift up to the task force rather immediately. At the same time, that there is additional work that we will be doing vetting some of these issues. So I think we'll come back to this, this discussion later on in our agenda. But I'll pause just another moment if there are any members that have questions before we thank Emily. Mary?
No, I'm particularly interested in looking at any statutes from other jurisdictions that have expanded the pool. So I guess Emily probably has that collected somewhere, and maybe she could make that available to us.
She does. She has shared that with me in a
Okay, great. Great.
Just this morning. And what I'm going to do is upload all those documents into a folder in our work group on the shared drive, and it's under the resource folder, and I will put it under, I'm grouping them by themes, and so I'm putting it under criminal trials, and there'll be a folder there for jury selection.
Great, thank you.
Thank you, Mary. I've also shared this PowerPoint along with all of those supporting materials, and I didn't get through all of it. So please feel free to take a look and see if there's any other questions that come up or anything else that I can be of assistance with.
I sure will. Thanks.
Well, thank you so much, Emily, both for the presentation and for your willingness to be a standing asset for the working group and for the task force more generally. We appreciate that.
Happy to do it. Thanks for having me.
We're going to now welcome our second guest, Ben Finholt, who's a staff attorney at the North Carolina Prisoners Legal Services. And one of the questions that cuts across much of the work that we're doing and a couple of the recommendations has to do with racial disparities in terms of who we lock up, who we incarcerate, and for how long. And Ben has agreed to share some of the work that he's been immersed in the last couple of years. Ben?
Thanks, Henderson, and thank you all for having me here today. So I also am going to begin sharing my screen, and hopefully then you all will be able to see my handy dandy PowerPoint as well. Like Henderson said, I am an attorney in North Carolina Prisoner Legal Services. I am currently running a project called the Just Sentencing Project that focuses on long-term incarceration. And so that's what I am here to talk about with you all. So the first thing that I want to talk about is how I arrived at the data that you're going to see momentarily here. So all the statistics that I have in my presentation are derived from data that is supplied by the Department of Public Safety. So this is a web link here, and I'm just going to click on it here and see what happens. I'm just going for it. It's working. So this is a page in a part of the, you may recognize this if you ever do searches for people in prison. But if you go to this tab that says downloads, you'll arrive here at the page I'm highlighting. And there are a series of links here. And this contains a treasure trove of data, if you like that sort of thing, about sentencing and incarceration in North Carolina going all the way back to 1972. So as they say there, all public information on basically people who have been in DPS custody since 1972. So there are probably people convicted of crimes who are not included in this data, but it is a very large data set. So DPS does use both race and ethnicity markers for each person that comes into its custody. Currently, the race categories that they use are this Asian/Oriental category, Black, Indian, other, unknown, and white. And then there are a larger number of categories that they use to basically define people's ethnicities. So for the purposes of my presentation, what I have done, just for descriptive sake, is to collapse these races and ethnicities into 6 distinct categories. The first one is Asian, and I included people. So one of the things that is difficult is looking at the data and seeing people who are labeled Indian, some of whom may be from the Indian subcontinent, and some people who may be, say, in North Carolina, Lumbee in their sort of racial makeup. So I have done my best to basically put anyone from the Indian subcontinent or Pacific Islands in this category: Black, Latinx, Native, people with 2 or more races or ethnicities, or there are some people for whom that's unknown in the data, and then white. So this is the sort of broad categories that we're going to be dealing with. Again, as sort of a social science matter, I'm not sure that this is exactly the way, the perfect way of doing it, but I think for our descriptive purposes, this was the way I chose to summarize what we're looking at. So the first thing I also would say is I just want to do a brief word about COVID, since we are unfortunately still in the middle of a global pandemic. So as I think many of us are aware, the coronavirus pandemic has disproportionately affected people of color, communities of color, and you can see the statistics here from the CDC below. And this is just a link to a CDC page discussing the various factors that have gone into this disparate impact. The other thing is that people who are in prison are also at high risk, because they are in these congregate environments where you essentially can't get away. Again, this is a link to CDC discussion of this topic. You know, you're moving people in and out of prisons, staff moves around within the prison, vendors who come in to supply meals and other things are coming in and out, and social distancing is basically impossible. So if prison populations are threatened, as we'll see, people of color are also threatened. So the first thing that I want to just sort of lay down as a baseline here is just general North Carolina demographic information. So in 1990, these were the sort of general breakdowns within the 6 categories of the racial makeup of North Carolina. And then you can see in the next column, this is the most recent census estimate from 2019. And so again, these are in these sort of 6 categories that I have identified that make it possible to work with the DPS data. So as you can see, the number of people who identify solely as non-Latinx whites has gone down. It's not wholly clear whether or not that is merely that is an actual change in the population, or whether or not just the way people are identifying themselves. But that's sort of our baseline that we're looking at, are these data as to how many people of each race or ethnicity are in North Carolina. So then we take a look at what it looks like inside of North Carolina prisons. So again, those first 2 columns are just the previous columns, same columns from the previous page. Then the last 2 columns represent the breakdown of everyone who's ever been in the OPIS system in that 3rd column, and then the current population of people who are being housed under DPS control. So as you can see, the percentage of Black folks in prison is way higher than the percentage of Black folks in the population, and the percentage of white folks is way lower. And the other thing you could see here is that this is not necessarily well, it's not at all a recent phenomenon. Even back, if you look at the historical data all the way since 1972, basically the state has been incarcerating Black folks at a rate way above where they are in the general population for quite some time. But I would also note that it has in fact gone up since the OPIS system started. So the next thing that I wanted to look at then was, okay, so what happens the longer you stay in prison to these rates? So I'm going to show you a few slides here. Excuse me, I'm going to go back. That talk about, that all have, they're sort of going to build on one another. So this again, in this first column is going to be the statewide demographic breakdown. And then we're going to sort of progress through various levels of long-term incarceration. So people who are serving at least 20 years, 55.8% of those people currently in North Carolina prisons are Black, and only 36.2% are white. A quick note about the 20-year marker. I ran this both for people who have served or will have to serve at least 10 years and people who will have to serve at least 40 years. And while basically there was about a 2% fluctuation on either side, but it was fairly consistent, which is to say that whether or not you look at a population serving 10 years at least or serving 40 years at least, it's all around, I would say, within a couple percentage points, at least on the Black-white side of these numbers. Obviously you can't do plus or minus 2% on the Native American population in prison because there's not that much room for error there. And it's not that this is error. It's just that the fluctuation is not so great when you look at that distinction between are they serving 10 years or 40 years. However, when we start to look at people serving life sentences, the numbers start to climb again. So again, people serving life with parole or a life equivalent sentence. So what I did essentially was to look at people serving more than 60 years. I think that the 60-year mark for me was at least, even if you're sentencing a very young person to that, I think the statement that the sentencer is making is, I would like it if you did not come out of prison at all. If you want someone to serve 60 years, this also allowed me effectively to capture the 80-year lifers from the late 70s. There was about a 4-year period of time there in North Carolina when you got life, it was actually an 80-year sentence. And so those people's, the sort of data around them is not necessarily labeled the same way as people with life sentences from fair sentencing. So, and again, LWOP, and just for anyone who's not familiar, LWOP stands for life without parole. And life without parole in North Carolina is a creation that came along with the Structured Sentencing Act for any crime committed after October 1st, 1994. So prior to that date, if you got a life sentence, you were eligible for parole at some point between 10 years and, well, sort of 100 years, theoretically, if they ran a bunch of things together. But you were eligible for parole at some point as a general matter. Structured sentencing did away with parole and brought in life without parole. You'll notice here that the number of Black folks dipped slightly there, but so did the number of white folks. So as you can see here, the number of white folks serving these really long sentences is steadily going down the harsher the sentence gets. And as a general matter, the number of Black folks is steadily going up. So these are very harsh sentences, more than 20 years, life sentences, life without parole, particularly harsh. And I would also note life without parole also would include folks who are on death row, the way that DPS does the sentencing data. Those people have a release date of never. So then where it gets more disturbing, at least to me, is when we start to look at two categories: juveniles, sentencing of juveniles, and violent habitual felon, which is sentencing that is discretion. Well, the sentencing is not discretionary, but the charging decision around violent habitual felon is discretionary. So a quick word: violent habitual felon status can be applied to anyone who has committed their third class A through E felony in North Carolina. And what's important is what the felony is at the time, what those prior felonies are categorized at the time the person commits the third felony. So for example, there are not a lot, but a few folks in North Carolina who prior to structured sentencing committed assault with a deadly weapon inflicting serious injury, which at the time was a Class H felony in fair sentencing. When the legislature passed structured sentencing, that crime got recategorized as a Class E felony. And there is at least one person that I know of, because I happened to see him doing the research, who had two prior felonies for assault with a deadly weapon inflicting serious injury, which were at the time Class H, pretty low level felonies at the time, who then subsequently, upon the conviction of a third Class A through E felony, received violent habitual felon status and is in prison for the rest of his life with no chance of release. So as you can see here, once we start putting that sort of discretionary piece, and that's a discretionary piece in the hands of the prosecutor. So the prosecutor can or cannot, depending on what they see fit to do, charge you with violent habitual felon status and seek conviction of that status. If you are convicted of that status, the sentencing judge then has no discretion and must impose a sentence of life without parole. So juvenile, people who committed crimes as juveniles and then received life with parole sentences, 74% of those are Black folks, while only 21% are white. Violent habitual felon, 80% of those are Black. And if you look at the juvenile life without parole, which is the harshest possible sentence you can give to a juvenile at this point in the United States, if you look at that, it's slightly higher. Almost 81% are Black and only 8.5% are white. So if you look at long-term incarceration of Black people in North Carolina, what you find here is they represent 21.5% of our state's population, 51.5% of the prison population, 55.8% of people serving more than 20 years, 60% of people serving life sentences, almost 60% of people serving LWOP, 74% of the children serving life with parole, 80% serving LWOP for this discretionary violent habitual felon status, and 81% nearly of children sentenced to life without parole. And so, I mean, just sort of as you look vertically, you can see as the sentence gets more serious and the person who has committed the crime grows in some ways less culpable, either because they are a child or because they have not committed a crime that normally comes along with a life sentence, the more likely it is that the person receiving that sentence is Black. The same goes, as you can imagine, if you just look at, and again, I don't intend to be monolithic about this, but if you look at all people of color, they were 25% of the state's population back in 1990, which is important because, you know, as you can imagine, a lot of people sentenced to harsh sentences were were sentenced at a time when North Carolina was not 37.4% people of color. And they represent nearly 60% of the prison population. And as you can see here, the numbers here are just going to continue to go up. So, you know, more than 2/3 of the people who will never be released from prison are people of color. 79% of the children serving life sentences are people of color. 84% of people serving LWOP for violent habitual felons, and a staggering 91.5% of the children who have ever been sentenced to LWOP in North Carolina are people of color. The last one to me was just, I almost couldn't believe it when the first time I ran the data. And again, that's historically all of the children ever sentenced to LWOP. So some of those people have been resentenced now, but that was those were their initial sentences. So the last thing that I wanted to talk about is infractions. So infractions in prison life are just a huge factor. And you know, I think that most of us are sort of generally familiar with the idea that if you behave better in prison, you might get out sooner, and you move upward through custody levels where initially you might be locked down most of the time, and eventually you can work your way up to minimum custody. So much of that depends on your infraction history, whether or not you can engage in work release or get home passes to go visit your family, whether or not you get parole. And then again, a link with COVID-19 here, DPS has a program called Extended Limits of Confinement, where people are finishing their sentences basically under probation in the community. However, that program is not available to anyone with a Class A or B infraction in the past 6 months. It's also not available to anyone who has committed what they call a crime against a person, which, as we've just seen, that's more likely to be a person of color, because people of color are disproportionately sentenced to long sentences for more serious felonies. So the problem on the infraction front is that there's a pretty neat black-white split in the way that DPS hands out infractions to people in its prisons. So again, this is the first column is the percentage of people in the current prison population. And then you see the percentage of the infractions that they've received. And so, while, for example, there are, Latinx people receive slightly less than maybe you would think they would, Native American people receive slightly more. The big divide here, and this is true also historically, not just for the current prison population, but for historically going back to, all the people who are in the OPIS system, is that essentially a bunch of infractions that should be going to white folks are going to black folks. And that makes it more difficult for people to get out on their minimum sentence. It makes it more difficult for people to get paroled. It makes it more difficult for people to be elevated into minimum custody levels, which would then naturally also lead to greater chances at parole. So those are the data that I have. I can go back to sharing my screen if there are pieces of that folks would like to see, but otherwise, any questions, please let me know.
These are extraordinary presentations, breathtaking, in fact. I think members are excused if some of these numbers are overwhelming. But let's pause and see if there are questions that bubble up even now.
Anderson, this is Mike. I've got a question for Ben. The data that you just showed us tells us that if you break down the different subcategories of people of color, that the infraction rate, the length of conviction, for all categories other than black and white, they pretty much track the general population data. But for black and white, the numbers are elevated for blacks and lowered for whites. Is that a fair summary?
I think it is. Now, again, I am an attorney, not a statistician. I think part of the problem in terms of like, you know, saying something statistically tracks is that the vast majority of North Carolinians would sort of, as a general matter, either be labeled racially Black or white. And so this may be a sample size issue where there just simply aren't enough Asian folks of Asian descent in North Carolina to know whether or not, you know, just looking at the counting numbers might not tell you whether or not they're statistically significant disparities there. But yeah, as a general matter, I mean, especially, I mean, looking at the infraction thing, I was pretty blown away. It's almost as though they just took a batch of infractions that should have gone to one group and handed them to another straight off. So yes, I would say generally that is also my impression, without having run sort of, you know, analysis to determine statistical significance and R values and all that sort of thing.
I
Mary.
have a question maybe for either Ben or Henderson. In terms of explaining to an audience of people who might not be lawyers, right? So there's only one punishment for there's two punishments for first degree murder, right? It's life without parole or the death penalty. And people might say, well, if you're convicted of first degree murder, that's what the punishment is. If you guys could address a little bit how we get there, right? Is it possible that are there charging disparities? Is it that juries are less likely to maybe find a diminished capacity defense for a person of color? I mean, you see where I'm going with this?
Yeah, one of the data sets that I've been trying to work with is from that site is called the sentence component data, and that has basically every judgment for every person who's ever been in Opus going back to 72. The difficulty with that, and so for those unfamiliar, like the judgment is the literal piece of paper that contains what your sentence is for one charge or a group of charges that were all consolidated. And each line in this data set is one judgment. The problem is that it's almost 5 million rows of data. And so it's much more difficult to work with. But one of the things that we're trying to look at is matching each judgment with what the initial charge was. And once we have that, I think we'll have a better idea of, for example, something like plea rates between these different groups of folks, because the plea rates would, you know, I mean, the open question is it just that white folks get plea offers to second degree murder and Black folks don't? I suspected that is true, but I'm not 100%, you know, I don't have the data yet to make that assertion, although anecdotally that would be, you know, what I would arrive at. Henderson,
I was going to throw in that we are working with Ben and the rest of the data team to answer those very specific questions that you'd asked Mary and others that come in. And so please, we can get offline. When we get offline, you can kind of wordsmith the exact answers or type of questions that we're looking for to get data for, and we can do that. We're running a little bit, about 10 minutes behind schedule, Henderson.
I think the only point that I would make here is that the scale between death sentences and these life sentences is extraordinary. I think my sense of death row is that the numbers hover around 140 folks on the road. It might be a little bit larger than that. Whereas the number of people serving life sentences, I think life without parole, Ben, my last grasp was something like 1,400, and that might be off. And I thought that the total number of life, virtual life, and life without parole hovered above 3,000. Can you give us any sense of what those numbers are? I know we saw the percentages.
Yeah, so I think I came up with something like 1,900 folks who are doing LWOP, and let me just, I have the actual, there we go. I have my numbers here. So in terms of the, you know, so right now there are, doing more than 20 years, there are about 8,500 people doing more, who have done or will do more than 20 years in prison. The life and equivalent number of folks doing life equivalent sentences is about 3,700. I have LWOP at about 1,900. And then the numbers dip from there. Like violent habitual felon status, at least according to DPS, has only been handed out 50 times, but 40 of them were to Black folks. And juvenile LWOP has been handed out 94 times. So, somewhere in the range of 8,500 people right now serving 20 years, 3,700 doing life equivalent, and 1,900 doing LWOP. It's a really big group of folks who are going to be there for a really long time.
Thank you, Ben. And I'll say that these numbers can be exhausting and overwhelming, but Ben is among the folks in our data and research team who are willing to pursue individual questions for later research. This informs so much of the work that we're doing. I've asked Mary to take a stab at carving out some part of the policy task that we've been given that's informed by the numbers that Ben shared that might be actionable in a relatively short time by this group. Mary?
Well, all right. So, as I had proposed, I think in that memo I sent around a couple of weeks ago, I think that one avenue to address some of these issues sooner rather than later would be bolstering the governor's ability to grant clemencies and bolstering the parole commission's ability to parole people. And I view those as sort of connected. Ben touched on, and we've touched on basically two issues where we know there are extreme racial disparities. One is the immediate and urgent issue of people who are incarcerated and vulnerable to COVID. And the other is kind of these long-term sentences that go back to the 1970s. And Ben, correct me if I'm wrong, but there are actually people in prison today for non-homicide and non-sex offenses that went there in the 1970s.
Yes.
And have never been released because they were sentenced to life.
Yeah.
And they're all African American, right? So it's not a lot, but it's still, I think, an injustice. But anyhow, one avenue of relief for this entire group would, of course, be going to the courts. But the wheels of justice turn slowly. Your ability to get relief, for example, I know some lawyers have been going to the Superior Court with habeas petitions for people vulnerable to COVID, state habeas, right? People have gone to court and challenged some extreme sentences under the 8th Amendment. The results are mixed. It varies from jurisdiction to jurisdiction. A lot of it depends on the local district attorney and whether they see fit to extend, I think, some mercy or discretion. So it's a patchwork and long-term and ineffective and solution. The other solution, and I like to think of this as kind of the small c conservative solution, is that we have an executive branch that was granted the power in the North Carolina Constitution to grant mercy in both of these situations. And my understanding of course, that would require an executive who wants to do that, but this is the governor's task force, so presumably he would like to see some progress. But the other thing that I have learned is that the executive branch staff that's looking at these issues is woefully understaffed and unable, I would imagine, unable to really give meaningful consideration to how to grant relief for these two classes of folks. A few years back, Ben and I and a couple of other lawyers at Prisoner Legal Services litigated a case about the adequacy of parole procedures for juveniles who were serving life sentences. And during discovery in that litigation, we found out just how hard our parole commissioners work, right? They don't just consider parole for the 2,000 people who are eligible for parole every year. They vote on DWI cases and revocation of post-release supervisions. And we found out they're making an average of 90 decisions a day about these things. There's no ability for them to sit back and consider a case and say, well, yeah, maybe. So it's just there's a volume problem. I think the same is probably true from the governor's clemency office. From what I've heard anecdotally from other attorneys, I don't have firsthand information about that like I do about the workload at the parole commission. But it occurs to me that it would cost a little bit of money, but not a tremendous amount of money to add some parole commissioners, add some staff, add people in the governor's clemency office. They could work hand in hand with DPS, which has the data and the information on these folks at an individual level, to consider cases one by one and say, hey, this person could be safely released into the community. So that's something I think just is feasible and needs to be done. I want to just kind of go back briefly on the COVID issue, because that's so immediate. The Department of Public Safety has extended what they call the early extended limits of confinement or early medical release program, but it's statutorily limited by what it can do of its own volition, right? There are certain types of crimes that are excluded from consideration. And as Ben said, if you've had a certain type of infraction, you can't be considered. But for example, you could have somebody who, say, had been convicted of second-degree murder. I know that's excluded, right? And they have served all but 6 months of their sentence, and they're at very high risk of COVID. And they're in they've been a model inmate, but they're not eligible for release under that program. The governor could let that person go, right, with the appropriate safeguards. So I just, and then one other thing I wanted to mention on this parole piece of it. When people were sentenced to parole eligible the sentences back in the 1970s and the 80s, there was an expectation that they would be paroled. People got paroled all the time. And then something happened called Willie Horton and the advertisement against Michael Dukakis. And when Ben and I did this Hayden litigation, we hired a statistician to look at the rates of paroles. And as soon as Willie Horton sank Michael Dukakis's campaign, people stopped getting parole. I remember talking to, we were in Wake County Superior Court on something or another, and we were talking to Judge Howdy Manning, who did criminal defense work back in the 70s. And he said, everybody knew back then that life meant 23 years. So it's probably better the way we do things now under structured sentencing, but the loss of parole as a feasible option for the executive branch is really a shame. And I also have a lot of faith, in this might sound strange coming from where I'm coming from, but I have a lot of faith in the ability of corrections professionals to make determinations about whether somebody can be safely released in the community. These folks know how to do that work if we give them the time and the resources that they need to do it and make these recommendations to a parole commission that actually had time to think about it, or to a governor for clemency. So that's my pitch.
Well, Karen and Michael, you've got quite a challenge. We have spent this morning talking about some really meaty issues, and Emily and Ben are to be thanked, and Mary is to be thanked for leading us in this conversation. But it is incredibly challenging for this group to digest all of that in the moments that we've got remaining. So Karen and Michael, my hat's off to you. You're going to be miracle workers for doing it. One escape valve is we've got some time between our next working group meeting, and the anticipation is there's going to be just humongous sharing offline and through emails. So Karen, do your magic for the moments that remain, but invite us to join in a process that can get us through this.
Karen gave me the wand today, so I'm gonna try to do some magic. Get my hat ready. So I want to note that we've adjusted the time of these meetings to give Justice Clark and Thornburg their time in chambers, and so I know we usually end at 9:15. But if folks feel up for staying a little bit longer, we can perhaps do that today to get some folks some time to have some input in conversation. Mercedes?
Section on questions we can scrap for offline.
Okay. So, we're moving away from the idea of low-hanging fruit because, like you said, Henderson, this is, I mean, the data that we heard today is a lot of heavy stuff, and so we're really thinking about how does this inform how we move forward around these ideas around jury selection, long sentences, parole, and I wanted to know get a sense from folks of what's bubbling up for you. We've had conversations over the last 3 weeks around jury selection. If we go back to Emily's presentation, she mentioned we emphasize and focus on pay as one of the reasons why folks remove themselves from being on juries. I know Mary brought that up earlier on in our discussions around jury selection. Okay, so I have the source list. We're missing parts of the population. They're not being updated as often as in other places, as came through that presentation. I want to go back to Emily's presentation around jury selection. Was there anything that bubbled up or that came up to the surface for you all as you heard that data and that conversation or that presentation this morning, that so perhaps moves you closer to thinking about, okay, this is something that could really work to alleviate some of those racial disparities that we're seeing in that case around jury selection?
So this is Mike. Didn't Emily say, Henderson asked her about the work that she's doing and that there might be recommendations coming forward, and did she say that's still some time off?
She mentioned that, or she had some materials that she shared with us. And I think the idea, Emily's still online. So if you'd like to share, Emily, we can work in maybe crafting the language of some recommendations that we want to make with Emily and with the group itself. Emily?
Sure. And what I shared this morning was both the PowerPoint that you saw, or you saw some of it, I didn't get through all of it, and also the supporting materials around reforms that have taken place elsewhere and research supporting those reforms. I'm happy to find other materials you may need, or to take a look at draft recommendations that you're working on. And I'm sorry for the kind of late notice on those materials, but you should have a Google Drive that has 4 folders related to different categories of reforms. And happy to take questions about any of those.
And once I get that material uploaded into our drive that you all have access to, I will send a link and we can start the review of that material and the discussion on how we can present it. Henderson.
Emily, let me say something that I understand might be a latent question in what Mike is asking, or at least my reaction to it is that there are some of these issues related to jury selection that we're prepared, I think, to make some recommendations based on decades of work. The source list for county jury commissioners needs to be expanded. Juror pay needs to be raised. I think the implicit bias work that Judge Thornburg has deeply immersed himself in, and that the School of Government is actively working to create a North Carolina video and North Carolina perhaps instructions growing from our bench. There are some of these things that are really shovel ready in terms of our committee making recommendations. I think the work around Batson that Emily talked about, that our Supreme Court has made some important decisions on, has really brought these issues to a pretty fine point, such that I think we're prepared to make some recommendations on those issues. But it may be that on some issues like Rule 37, we still need to do some sussing out. Emily has suggested that there's a committee at the School of Government that's looking at the video. It may be that it'll take time for the actual video to come out. one of the suggestions I have is that during this week or 10 days between now and our task force meeting, is that we offline sort of work with what we've got and come up with a recommendation that we can lift up to the task force. They might have some questions. They may refer more things to us to pursue, but we're pretty solid on some of the general theme. And I think, Mary, some of what you said with respect to the clemency expansion, is that something that you could help craft language over the next 10 days so that we can pass on whether we're ready to make a recommendation? And I think the issues surrounding COVID-19 certainly bring some urgency to that question. Mary?
I mean, I think I can draft something certainly about the concept and the rationale. What I don't think I'm prepared to do is probably put forth the related numbers as to what it would cost by way of staffing. So, but if we could get, if there was consensus on the concept, I guess that could come later.
Brooke, I see that you've unmuted yourself, so I want to give you some space to talk. Go ahead.
Yeah, I was just going to say that I think Emily kind of covered the work is being done based on the issues that we've already discussed and problem areas we've identified, and so that's really promising. And I guess I was thinking, how can we better work together? What can we do to help, further the work that Emily's doing? Or I know that you said, Emily, you're willing to help us as well put forth those recommendations. I think it's a great idea. This may be kind of off topic a little, but I emailed something to Mercedes regarding jury instructions. Emily, I'm sure you've looked into this, out of a Dallas, Texas court. It's actually a civil court, but I think it was Judge Parker there developed a task force and adopted an implicit bias jury instruction from a federal court. And it seemed to be working well. There was a 6-month study. I'm not sure the outcomes yet, but they were measuring how the instruction affected the jurors and what kind of impact it had on their decision making. So those things are really, I think, it's interesting, but it's important, I think, to look at the work that's being done already. And we don't have to reinvent the wheel necessarily, maybe use what other jurisdictions are using and what works well for them.
That segues really well into what we were going to circle back to, and we, I think, lost some time on, was our proposed work schedule. And so I'm going to circle this document around after the meeting, but ultimately I can share my screen really quick too, just so you have something to look on. But ultimately we're here in our third work group meeting, August 18th, and we're proposing that if we had any initial recommendations that we made those, so we might want to make a decision on that. But then going forward, we were going to have a presentation on, basically I broke this down by topic areas, and then at each meeting we could talk about various ideas that fall under topic areas. So our first we'd look at fines and fees, and then also have a presenter to talk about the second look at. So each meeting we would have two-part discussion, and this is open for feedback. We'd have another task force meeting and going into some more presentations about the death penalty and racial disparities in there. Also some more discussion on the second look at, and then a presentation on collateral consequences, which and the reentry work. Breaking it down like that, I think for sake of time, I hate to go through all of this with everybody. Again, the idea is we would have a discussion and a presenter on each topic that would present ideas, and then offline we would work together to formulate and wordsmith, if you will, specific ideas or recommendations, and then from there discuss those at the work group meeting, and then present those to the task force as everybody agrees.
And Brooke, just to give you a heads up, on the September meeting, while there's to be announced in terms of the presenter, certainly the thought is you would at a minimum be the person to distill some of the work and thoughts into what approximates a proposal, so that between now and then we would try to identify an appropriate research person, and Mercedes is ahead on that game, who might provide a presentation that gives you a base, more of a basis, much like Ben did today, that would inform your work, much as Mary did with her work with respect to clemency. But part of what we're asking for input is this general approach helpful, that we bite off a big chunk of what we've identified as important, and figure out ways within the working group that we can process it, and then in between meetings do even more due diligence, investigation, and review. Mercedes, wow. I think there's an amazing amount of content that we took on today. And Karen and Michael, I don't know that we can do more than this to get a sense of whether there's general consensus on this issue, or whether that consensus gathering is something that we need to do offline over the next 10 days. Right. And Karen and Michael, I defer to you on that question.
Well, that's a good question, because what I just over the last couple of weeks and just in this conversation today, I think what's happened is we've kind of, some congealing has started to happen, where it feels as if we have there's some things that are, like I said, kind of coming to the surface, right? As you said, increased pay in jurors is needed, increased jury pay is needed. And then we have some data to back that up. I recall, Emily saying that when in cases where we increase, if we increase pay, we increase diversity, right? So what I'm looking at is for each one of these ideas: increased jury pay, expanding source lists, implicit bias training for all court staff, bolstering governor's clemency, parole, giving more. Thinking differently about how we do parole, and just opening up that conversation, is that we have sort of this structure of ideas of these are the things that we think are good recommendations, and then we have to think about the why and the how, right? And so as Mike in an email that we got through is thinking about, okay, so the focus here is how is this impacting the racial disparities, right? So why is this particular recommendation for increasing pay for jurors going to impact the racial inequity in that arena, right? How is expanding source lists going to impact or increase diversity in jury pools? And so it's like you said, Henderson, we have all that data from decades and decades of research and recent research coming out. And so now over the next few weeks, or the next 2 weeks, or before the task force meeting, is thinking about how do we pull that together? How do we say, this is what we're saying we recommend, here's why we recommend it, and here's how we can get that implemented. Because Mary brings up a good point, right? That if we're gonna say we're gonna increase staff, how are we going to increase staff? Where's that money going to come from? I think that if we think about it in that way, of that process, we can get to a place where the recommendations are streamlined in such a way that when we take them back to the task force, everybody can get the information that we've gotten in such detail in a synthesized manner that allows for them to feel like they can move to saying, yes, I think this is something we should recommend for the entire task force. Does that make sense? What I'm, how I laid that out? I just want to make sure if anybody has any questions for what I'm proposing. That's in a lot. Yeah.
It does, and I'm looking at Brooke and Mike and Mary. I think Judge Thornburg may have stepped away, but I think in some general fashion, it seems like we've got consensus to go forward in this direction and to use the next 10 days very productively offline to refine suggestions and proposals. So I'm imagining that we're going to be active as a work group during the next 10 days, even if we're not, even if we've given ourselves a breather and won't be assembling for a formal meeting next week. So do we have a thumbs up for that general way to proceed? Excellent. Mercedes, anything to close us out?
I think we are good. I will follow up with everybody offline with the materials that we were shared with today, and links to direct attachments and also links to where they're shared online. And then please don't hesitate to follow up with me on any data questions or research questions. If you're not hearing from me, I'm here, and we will see what we can do about getting the work done over the next couple of days.
Thank you all. Thank you so much.